Hi and welcome to this video. In this video I'm going to review your discussions for week 4 and I'm going to provide you some comments on what you said. This is my second video. The first video failed because of some technical challenges. My iPad ran out of space, so it got interrupted, so I have to redo the whole video again. So the first video was about 20 minutes, so I've tried to make this shorter. That's why I'm going to skip some of the comments that you guys put on the discussion board. And we start with the questions that I asked in week 4. Week 4, there were 3 questions in the discussion posting. The first question was, have you ever been in a situation in which the law became an impediment for your or your supervisor's managerial practices? If yes, what has happened? If no, does it mean that the law is always the source of your managerial practice in your job? In the second question, I asked you, in this module, you watched a video about people being jailed for failing to pay fines for their city. The city of Childersburg contracted out fine collection task to a private probation company. As you saw in this video, city officials are short of staff and cannot dedicate any personnel to carry out this task. To what extent do you think the city of Childersburg's decision to contract out the fine collection to a private probation company fits in the rule of law, and does their decision comply with the constitutional, statutory, or administrative laws? Do you think managing for efficiency contradicts with the rule of law in this case? And I ask you guys to use the textbook and other course materials in your discussions. And in the final question, in question 3, I ask you to take a look at the World Justice Project's The Rule of Law Index 2017-2018 and review the United States counter profile in the document, and explain in what areas the US thrives and needs improvement. And also I ask you guys to compare the US to one of the countries that rank higher in this index. And many of you guys picked United Kingdom for understandable reasons. We share a lot of common components in our governmental system. A lot of logic is similar in the US and UK. But a few of you picked some interesting countries. I think one of you guys picked Singapore or one of those countries in that area, and a few of you guys picked countries from Europe. There was one, I think Denmark, and I think that was it. Most of you guys picked the UK. Without further ado, let me provide you my comments for each of your discussions. Starting from Michael Legudes, and Michael, please correct me if I mispronounce your name, and I'm sorry if I mispronounce your name. But that happens to me a lot with my first name. People see my first name as Faith when they see it for the first time, and they call me Faith, and I have some funny experiences that I can share with you in a different setting. Anyway, Michael shared a good example of tension between law and management in his personal experience. Thank you for that. And he said the decision to contract out the fine collection function to a private company does not in and of itself violate the rule of law. And I think that's correct. You can contract out a service to a private company as long as you think that the private company is going to do a better job in delivering the services. And he continued saying that, I do feel that what comes next, as portrayed in the video and news articles, does, however, it says, contradicting the rule of law. I think that's the point that many of you guys highlighted. Contracting out the service is fine, but the example that we had in this discussion board probably is not a good example of managerial practice that fits in the rule of law. So there are some problems with that. And Michael also said, profit should simply not be a factor when it becomes a factor. The credibility of our government as a whole is rightly called into question, and I couldn't agree more with Michael. So that's an important point. And many of you guys said similar things. So I will continue with Francisco. Francisco shared an interesting example of law being an impediment for management. It's really interesting to hear that counties do not have the same authority with cities in terms of enacting building codes. And I would like to know the rationale behind this decision. And Francisco, if you know the rationale behind not allowing counties to enact city codes, but allowing cities to enact building codes. Please let us know the rationale behind that. I would really appreciate that. Francisco touched an important point in his answer to the third question. He said he is surprised to see that U.S. is weak in enforcement of regulations. Well, indeed, the matter of regulations, enforcing regulations, is a matter of the relationship between the private sector and the public sector. I will take you back to the establishment of the governmental system in the U.S. And remember, I mentioned to you that there are three important steps for development of a modern state. The first one is the establishment of the rule of law. The other one is the establishment of a merit-based, well-functioning bureaucracy, and finally, the establishment of democratic institutions. In European countries, the order was first the rule of law, then a merit-based, well-functioning bureaucracy, and finally, democratic institutions. In the US, the situation was a little different. First, we had the rule of law. We inherited it from Britain. Then we had democracy. That was quite prominent, especially during the spoils area. New migrants from Ireland and Scotland were easily integrated in the political system because of the spoils system, because politicians could hire their followers and supporters in the governmental and the public sector. And finally came the merit-based bureaucracy. And merit-based bureaucracy was developed in the U.S. after 1883 Pendleton Act. So that was late 19th century. So there was clientelism and patronage has always been a part of the American bureaucratic system until the late 19th century, and it's still the part of the governmental system. If you look at the federal level, when a new president is elected, he or she has the right to appoint up to 7,000, maybe even more, positions through a non-competitive process. So all these positions are listed in a document called the Plum Book. You can find the Plum Book online. I think I provided you the most recent Plum Book in my earlier discussions, earlier announcements. You can take a look at it. So it's an element of patronage and clientelism still existing in our federal system. So it's still in function. That means the government is not as powerful as we think it is. And compared to European countries, the government, especially the federal government, is relatively weak, especially when it comes to relationships with the private sector. The private sector has always been powerful in the U.S., even before we had a good governmental system here. So it's a challenge for the government to enforce regulations on the private sector. Private sector can use interest groups, can use their lobbying power, they can use other means for influencing politics and undermine all these regulations that they think will threaten their profitability. So that's why there's a gap between the US and European countries. Another important thing is that in Europe, the whole European system is a system of standards. So you have to meet certain standards, especially in law enforcement and not law enforcement, in rule enforcement, in regulation enforcement. If you cannot match these standards, you cannot be the member of EU. So in EU accession process, many countries, they harmonize and update their legal system, their economic systems and so on with the European Union system, so that they can match the European standards in their governmental actions, in their economic actions and so on. So there's a major difference between the European countries and the US in that sense. Taylor made an important point. He said, jailing indigent people is a waste of scarce resources, such as a jail cell. That's, I think, very good point. I think a few other people shared the same idea, and thank you for bringing this up. It's an important point. Josh shared a positive example about the law. Let's remember the definition of the rule of law. Rule of law prevents against arbitrary, capricious, and non-transparent acts of public managers. In his example, the law and legal institutions protected the due process rights of his peer and prevented public managers using their authority in an arbitrary way. So Josh's example is an excellent example of the legal system or the rule of law preventing public managers' abuse of power or making arbitrary capricious decisions that are not legal in essence. Josh gave a long and detailed answer to the second question, and his last paragraph is important. He said, where the disconnect occurred was at the judgment level, where Mr. and Mrs. Fugate were never assessed on their ability to pay the fine. To place blame on third-party company is easy and makes them a target, and yet does not solve the problem at all. With regards to efficiency, if the municipal judge had followed the rule of law and assessed the husband and wife's ability to pay properly, I argue efficiency would have been maximized because litigation would most likely have not ensued. I think he made an important point, and I would like to add a couple points to his discussions. Josh is right regarding the municipality's failure to follow due process and assess Mr. and Mrs. Fugate's ability to pay those fines. I think they could not do the assessment of Mr. and Mrs. Fugate's ability to pay fines because they didn't have the personnel. That's why they contracted out the whole service. So there's a challenge here. I would like to add a personal bias here, and I'm going to introduce this personal bias not as a college professor, but as a regular person who has a different experience with government institutions in different settings. And you can always disagree with me here. There's no clear right or wrong answer, and I think it all depends on your viewpoint. I think judicial services are inherently governmental activities. These kind of activities should never be contracted out to private companies. There are some non-essential components of these services that you can contract out, things like cleaning or janitorial services or procurement and things like that. You can do through contract out, and these things bring efficiency, and these things allow you to focus on your core functions. But if you think a function is an inherently governmental activity, or you are not 100% sure if it's a core component of judicial services or justice system or not, if you think it's in a gray area, I would not contract out such a service to a private company, because eventually, if you cannot manage a contract like that, it might end up violating some people's legal rights, and this is something you don't want to do as a government official, especially in the legal system. So that's kind of my bias here, and I think it's not a good idea to contract out such services overall. And feel free to disagree with me. This is a personal thing, and I'm not saying this as a college professor. I'm saying this as a person who had different experiences with different governments in different countries. Okay. Cody shared an interesting example while answering question number 1. Thank you for that. I think his answer to the second question is quite interesting. I would like to add to his discussions. I will go back to my earlier comments and say judicial services are inherently governmental activities. I think no government shall charge people any type of court fees. Access to the judicial services should be a citizen's rights. So if you're a citizen, you should be able to go to the courts and do your business and leave without thinking about money at all. And charging people some court fees or transactions or things like that, these kind of things don't sound right to me, right? If you think that you need money to run some basic legal functions, you can add a little bit of taxes and have the whole community pay for such services instead of charging on the people who get these services. I think this is in the nature of running a government. Now, certain services inherently governmental, I think activities and services are public goods that everybody must provide. And even if some people don't provide, it's fine. Still, you can provide these services to those people. These are services like national defense. So, my personal bias, again, you can disagree with me here. Finally, Daniel's example in his answer to the first question was pretty interesting. And the example he gave evoked a similar case that I'm familiar with. As you know, some parents don't want their kids vaccinated, and they believe that the herd vaccination can protect their kids, and they usually don't do vaccination sometimes because of religious reasons, sometimes because of ideological reasons. And if too many kids don't get vaccinated, that creates some public health issues. As public managers, you don't have the authority to vaccinate these children without their parents' consent. And in some cases, there are certain kids with weak immune system, and they are impacted by infectious diseases more than their peers. So in such situations, the parents of the children with weak immune system, they ask schools to have all the students in that school vaccinated, because one or two students without a vaccination can infect their child with an weak immune system and can cause some major health problems for their family. In that situation, I think still the public managers don't have the authority to force vaccinate these kids who are the friends of these children with weak immune system. Another example is that some religious groups don't want their kids receive certain treatments. For example, some religious groups do not want doctors do blood transfusion on their children. Usually doctors must get parents' consent to do certain procedures on children, but if there's a life-threatening situation, they just don't listen to what parents say, and they do whatever they have to do, including blood transfusion. So here, do doctors break the law? I don't know, but they usually use their discretion and do whatever that is necessary to save the children's life, and do their procedures. That's all for this for this review video. There are more to cover, but I tried to keep my video short. I think many of you guys did an excellent job and shared some common points, so there is no need to repeat all of your discussions, but I tried to highlight the discussions that I saw quite interesting and worthy of commenting on. So thank you very much for your time, and please let me know if you have any questions. Feel free to send me an email or contact me, and I look forward to hearing from you. And also, please make sure that you are eating healthy. There's a flu outbreak nowadays, and stay warm and pay attention to your health. Take care.